All righty. Good morning and welcome, everyone. My name is Betsy Longi. I'm one of the owner liaisons with King County Housing Authority, and today's Regional Landlord Symposium is hosted for you all by a collaboration between Seattle, Tacoma, Pierce, and King County Housing Authorities. Really, the purpose of today is to provide folks who work in the housing industry information on topics that you might find valuable, but that also pertain to you as housing providers. If you've attended one of our symposiums in the past, then you know that presentations and topics like we'll be covering today, they're really curated based on the feedback and recommendations that we receive from you. So across King, Seattle, Tacoma, and Pierce County Housing Authorities, we do work with thousands and thousands of housing providers. And your partnership is absolutely critical in the mission that we all serve to be able to provide decent, safe, and affordable housing for families. So thank you all for being here again today. We're super excited to have you with us. If you are unable to stay until the end of the final session, not to worry, we will be sharing presentation materials and a recording of each session after the event with all of the registered attendees. So with that, I will pass it over to Alexis from Tacoma Housing Authority to go over the agenda for the day and some housekeeping items. Thank you.
Thank you, Betsy. Again, thank you guys so much for joining us today. We have almost 400 people registered for our third annual regional PHA symposium. So thank you guys so much for attending. I want to go over a couple of housekeeping items. So our agenda today, we are going to have a legislative update from Christopher Cutting with Rental Housing Association of Washington. And then we are going to have Nicholas Uvo with Department of Commerce talk about the Landlord Mitigation Fund. And then we are going to have our inspectors from each of our housing authorities talk about common housing quality standards, general housing quality standards items. And then for our last session, we are going to have Anne from Seattle Housing Authority talk about the Inspire inspection standards. We have a packed agenda today, and we do have a couple of breaks in between the sessions. So after our legislative update at about 11:50 to 12 o'clock, we're going to have a 10-minute break. And then between 12:45 and 1:10, we're going to have a lunch break for you guys. And again, we are going to be recording these sessions. We're going to pause the recordings at the end of each presentation and open it up for questions and answers. Please use the Q&A feature here in Zoom to ask your questions, and we will try to get as many answered as possible. But again, we have almost 400 folks registered for today's webinar. So we will try to answer as many as possible, but there might be a chance your question is not answered. If that's the case, you can reach out to Rental Housing Association of Washington for legislative update questions, or your local housing authority for housing authority specific questions, or Department of Commerce if you have any questions for them. And I'm going to go ahead and turn it over to Garam with Seattle Housing Authority.
Hi, my name is Garam Mulday, and I'm one of the owner liaisons at Seattle Housing Authority. And up next, we have Christopher Cutting. And Christopher is known as a tireless advocate for housing providers. He has been practicing residential and commercial landlord-tenant law, judgment enforcement, and appeals since 2009. He is an 8-time Rising Star attorney in Super Lawyers Magazine and holds a perfect 10.0 rating at avvo.com. Before going into private practice, Christopher served as a law clerk to Judge Mayweave Van Daren at the Washington Court of Appeals. Christopher currently serves on the board of directors for the Rental Housing Association of Washington. He is the vice president of the organization and the co-chairman of the legislative committee. He is the co-author of the Residential Leasing Practice section of Washington Lawyers Practice Manual and has published articles in several legal journals and real estate trade publications. Christopher is also committed to education. He is a frequent presenter at the legal education courses hosted by the state and local bar associations and private groups, and is a licensed clock hours inspector for Washington real estate broker. Christopher also has been the author and or co-author of housing providers officials' response to several legal and legislative actions. And I'll pass it on to Christopher for his presentation.
All right, Guillaume, thank you for that kind introduction, and thank you, Alexis, as well, for putting this on today. Real excited to be part of this great panel, getting info to housing providers throughout the area.
And Christopher, you should be able to share your PowerPoint presentations as well.
Oh, great. All right, let me get that going. Let's see if we can make that big. Oh, looks like I don't have that authority.
Go ahead, you should be able to share now.
Okay, yep. There we go. Does that look pretty good to everybody?
Yes.
All right. I'll put that where I can see it. So I'm excited to talk about a lot of different landlord and tenant regulations going on around the area that everybody's managing property today. We're going to start out with Tacoma, and then we will move north into King County and talk a bit about state procedures as well. I think Alexis had already let everybody know, but do please take advantage of that Q&A feature. I love addressing people's questions. I think it's a great way for me to make sure I'm giving you the information in a way that makes sense and works for you. So please don't be shy about asking questions. There's me. We already heard me. And here we go. So we're primarily in this first unit, we're going to focus on Tacoma and state and sort of what's new, what's changing, how to keep track of all that's going on. We're also doing a legislative update for the election in just a hair under 2 weeks now for City of Tacoma residents on an additional set of changes to their rental housing code. There are a big set of changes already in place, which is a lot of what we're going to cover. And on the ballot in 2 weeks is going to be additional changes beyond what we cover and what we're talking about today. So a big one for everyone is always serving pay or vacate notices. Back in 2019, 2018, it's getting rusty for me now. We extended that period for residents to pay from 3 to 14 days. Anybody who's been in the industry for a long time, I'm sure remembers that. The idea behind that time period extension really focuses around helping residents stay housed. A lot of the policy change, especially at the state level, but at the local level as well, over the last 5 years has focused on using the eviction process not to displace people from their housing, but as a way to funnel them into lots of different support resources. And it's really designed to keep people in their housing. Things like the Rights Council, getting public defenders to assist you in eviction, the extended amount of time to pay, the 14 days, idea behind that being to get you to another paycheck. It's a pretty heavy amount of people are paid every 2 weeks or semi-monthly. That 14-day period allows folks who have had just a temporary interruption in their ability to pay to get over that kind of speed bump, that hiccup, and save their housing at minimal cost to both the housing provider and minimal damage to the resident in terms of their rental history, their cash flow, et cetera. At RHA, we have city level packets for every different local jurisdiction that we're going to talk about today, which has specific requirements for their city or county. And then there's also a generic state level form that works everywhere in the state that doesn't have a specific requirement. A delivery of these notices is really the key part to it. It's not that hard to do it correctly, but you've got to do it in exactly the right way every time. So that requires genuinely attempting to hand deliver it to the resident. So you want to go out to a property, you knock on the door, you give them a reasonable amount of time to come to the door to answer. That's going to vary by the nature of the property. Question I get all the time is, well, how long should I wait? And that really, how long would you wait if you really wanted someone to answer that door? That's going to be a bit different if you are in a rural area and you got a big house on a big piece of land than what you would expect for a studio apartment in the middle of a city. So think about it that way. If I really wanted someone to come to the door, how long would I wait? And you want to wait at least that long. If someone does answer, as long as they're not too young, 12, 14, somewhere in there is about the youngest you'd want to hand paperwork to. But anyone that age or older, you give all of your copies of the documents to that individual. And anytime that you don't personally hand one to every single adult that lives at the property, and it's pretty rare for 3 people to answer the door. So this is almost all the time. You also mail copies. If nobody of appropriate age comes to the door, either nobody at all or only somebody pretty young, then you post the documents in a conspicuous place on the property. By convention, that is face out on the front door. The goal here is that it's got to be really obvious. I hear from residents from time to time that find this embarrassing, to have a big notice on your door that says you didn't pay the rent, that how much you owe in rent. And that can be certainly uncomfortable for folks. And I really appreciate the sentiment that I get from a lot of clients and housing providers that I work with, that they want to give this resident some privacy. Unfortunately, by law, you're not allowed to do that. The purpose of this notice is it's that last formal opportunity to get this addressed before a lawsuit can be started. So it's really important that it's just incredibly obvious. That's why we have it both posted on the door and mailed to the property. That's why it's got to be open and conspicuous. So, you don't want to put it face down. You don't want to put it in an envelope. I have from time to time folded the top of it over, so the names and the name of the document, that 14-day pair vacate part shows, but not the total amounts due. I'd be a little bit careful doing that because courts sometimes will find that is improper. Usually they're going to be okay with that, but it's maintaining that obviousness of what it is. And we really feel for the resident when that happens, but unfortunately it's a legal requirement. We've got to deliver it in that open and obvious way. So that's what you want to do. In terms of number of copies, you want to provide one for every adult that is living at the property. So that's usually going to be everybody on the rental agreement at a minimum. I always recommend providing one more. In addition to that, in case there's some unknown person living there that you're not aware of, a change in roommates, and uncle's staying for a couple of months, and the resident forgot to tell the household, the property owner, whatever that may be. Better to give too many than too few, and then you mail the same number that you post up to the property. For properties that are subject to the CARES Act, that 14-day compliance period becomes a 30-day compliance period. And to be covered by the CARES Act, there's 2 real tests for that. One is if the household gets some sort of rent subsidy that's supported by funds from the federal government. So anybody who's in public housing, anyone in the Section 8 program, those are kind of 2 of the most common ones, but tax credit properties and federally subsidized properties like housing for the elderly, the rural development properties, HUD buildings, et cetera, are all going to be covered. Anytime where your income controls how much you pay in rent, or you have a maximum amount of income to live in the property or the unit. that is going to be covered. And then in addition, if you have a federally held or federally backed mortgage. So this is the property that I live in, actually. I'm not there today, but my home, I got a conventional loan from a bank, and about 6 months after closing, my loan was sold to Freddie Mac. So I didn't have anything to do with that. I still make my payments to the same place. It doesn't impact anything for me about my experience holding the property, but if I were to rent that property out, then it would be subject to the CARES Act because that is a federally held mortgage. That's probably the one that's the hardest for owners of property to keep track of, because the only reason I know that is I'm a lawyer and I think about these things. I got a letter in the mail, I understood the importance of it, and I stuck it in a file with my other mortgage documents. If I didn't work in this area, I probably wouldn't have known what that was about. So it is something to think about, to keep in mind. If you are a CARES Act covered property, that impacts any notice that you would give a tenant, which could require the tenant to vacate. So a pay rent or vacate notice, most of the time the resident doesn't vacate, but it is possible that they could be required to vacate on that. So it becomes a 30-day. Likewise with 3-day notices to quit for illegal businesses or criminal activity, with comply or vacate notices, with the few types of termination notices that require less than 30 days. Usually that's terminating a tenancy for a roommate. That's different, it's worth noting, than how other states apply the CARES Act, but Washington's been pretty uniform about applying it that way. So that's at RHA, what we recommend for all you. I talked about this a bit already, but residents facing eviction who meet certain income thresholds are entitled to a free public defender to defend them in their case. They're going to get at least 3 opportunities to connect with that public defender. When they get a pay or vacate notice, they get some mandatory state language in it, which tells them about that right and how to connect with that resource. In my experience, not very many residents do that at that point. They're really focused on getting the money together or getting the help they need to make that payment. So they tend not to reach out and seek that funding at that time, or seek that support at that time. They get another notice when the eviction action starts, which is we're going to talk about in just a couple of slides. That's the summons and complaint that formally begins the action in court. And then they will get a third opportunity if they appear in court. The first time they appear in court, the actual judicial officer, the judge or the court commissioner, is going to let them know they're potentially eligible for that and give them an opportunity to be screened and approved for that assistance prior to the case moving forward. In Tacoma, we have a ballot measure coming up in about 2 weeks on Tuesday the 7th about another set of expansions beyond what we're talking about today to the local housing code for the city of Tacoma. We've got a link in the slides today to that material if you want to go and check it out. But I do encourage everybody here, no matter why you're here, you're working in this area and getting educated on the pros and the cons of that ballot measure, and making an informed choice about why you want to support it can make a big difference in your business and day-to-day life going forward. So please do take an opportunity to do that. Unless we have time and questions about it, we're not really going to get into the details of that measure today, because we're going to talk instead about the set of laws that were passed by the council a couple months ago that are in effect now. The provisions in effect now cover a few. They have special requirements for a few newer landlord and tenant relationships. These are more specifically defined than it's state law, and they give additional rights and obligations both for the provider and for the resident. One of those that they talk about is master leasing a property. So where we see this most frequently is in bigger single family homes. The property owner might want to provide more affordable housing. So they choose to rent out units by room instead of renting out the whole house to one family or one household. That's a really great way if you have a bigger property and you want to provide a bit more access to some affordable rents, that you can do that. And you spread out your risk a little bit doing that as well, because you have several different households contributing to that total income. So when there's a change in one or two bedrooms, it's not going to impact your total income you get on that property. So it can be a real accessible way for a lot of folks to provide a little bit more affordable housing. Sometimes they set those up instead of managing it yourself. You have a master tenant who rents out the whole property, and then he or she sublets out the individual rooms to different folks. So that's what is being talked about in the code when you see references to master leaseholder, master lease, and shared housing as well. Tacoma has some specific education requirements that someone who's listing a property for rent has to include at the time that they first have an inquiry from a potential renter about their property. They need to give real specific details about the ability to pay rent in installments. They need to provide 2 different resource packets. One that gives a bunch of information to the potential tenant about their local and state housing rights. And then the second is a link if the tenant wants to do research on licensing and compliance history for the property itself. It's a link to a city maintained webpage that has a database of all those sorts of public records. We'll get into detail about these things in the next couple of slides, but there are some specifics on asking for and using social security numbers, criminal history, and how you can calculate a rent to income requirement as well. And those are all bigger topics, so we'll touch on each of those individually, but it's important to keep in mind that you want to provide that information in that initial packet that goes to anyone interested in renting the property about, what are your standards and your procedures for screening and approving tenants, and what's the rent going to be, all that different information. And that should be provided, and this isn't state law, and city supplements it with additional pieces of information that should be included. That should be provided before collecting any information about an applicant. So if you do any kind of pre-screening, you want to make sure they get a copy of this packet before starting that pre-screening process. In that information packet, we mentioned a couple of these things already. There's going to be the resource information for residents and the information about their affirmative right to pay in installments. The city has, and this just came out just before we got this set of slides published, their required form of installment payment notification. So that actual document is going to go in the resource packet that you get to the resident or the potential applicant, excuse me. They're not quite a resident yet. And it's important that that's included in that full disclosure that you give to residents before collecting information about them. You are still in the city of Tacoma allowed to collect social security numbers as part of your screening process, but you have to have an alternative way for residents to submit to screening as well. If they choose not to provide a social security number, that cannot act as a basis for denial. They can provide you with an alternative method of assessing their eligibility and financial qualifications to rent the property. But if they choose not to do either, you do the best screening that you can and you make a decision based on the available information. So if the resident chooses not to provide that social security number or one of these alternative methods for background screening, you can deny tenancy based on the lack of information, but not based solely on their decision not to provide that. State law operates here as well and slightly differently. What state law provides is you can't make housing decisions based on someone's immigration or citizenship status. So if they lack a social security number, for example, because of their immigration status, that can also not factor in as a basis to make the decisions. Because of the specific way that Tacoma operates, that's not going to come up very often For Tacoma housing providers, if you are in compliance with city law, you are in all likelihood just not going to have that scenario where you have someone that you're looking at potentially denying because they don't have a social security number. The other kind of aspect of this to keep in mind is that there are a lot of ways to screen folks whose primary residence is in another country who don't have a local number, or who their social security or taxpayer number is so new that they haven't established credit using our system. Other countries have rental properties too. They don't have these sort of credit history reports for the most part that we have in the United States, but they have equivalent things that they can do. So really think about, what am I trying to do in getting this information, and how, sort of what other types of documentation would help me make that same decision. And there are some companies out there that specialize in screening foreign nationals, and you can connect with one of those if you want to, or do your own sort of individual assessment. For my rental property, I have a foreign national residing in one of my units right now, and he has a social security number and credit, but it's really, really short. So he didn't meet my regular screening standards, but he provided me with some extra documentation about his rental history, about his income, and from his home country, excuse me. And then using that information, I was able to determine that, he was going to be a great resident. So I rented to him, even though he didn't technically meet those requirements. The reason that he missed him is because he's relatively short amount of time in the United States, not because he had a bad history while he was here. And sort of having that flexibility is real important when you get applicants of that nature as business. You don't want to miss out on somebody good, and then for state and city legal compliance as well. When looking at individuals' criminal history, there are, again, two different layers involved in this. The first is that under federal law, and the Washington Office of the Attorney General has adopted these requirements for Washington as well. You can't make blanket decisions based on an individual's criminal history. You have to assess everybody and their history individually. So that is going to mean, for example, you can't have a no sex offenders rule in your property, but you can require someone to disclose that they are registered as a sex offender, and give them an opportunity to provide additional information about what happened, why, what they've been doing to rehabilitate themselves, to show that they're not a threat to the community, and to show that they'll make a good resident. And then you have do an individual review of that information they choose to provide, as well as the information you get from your screening, to decide, is this specific person, do I have a business reason that is non-discriminatory, that this person will be a problem in my building, that it can be a danger to my other residents, or that they're going to be a danger to my business or my property. Tacoma also endorses that holistic, individualized assessment. And then they put some specific guardrails as well on what aspects of an individual's background you can and can't consider, how long you can do that, and the durations comply pretty strictly with state law. So it just makes it a little bit more accessible to identify those, as well as outlining some specific crimes that you can and can't consider at all. But just because you can, for example, consider an arson conviction on somebody's record doesn't mean that can be a blanket basis to deny. You still have to do that full evaluation, looking at all the information, doing that on a sort of an individualized case-by-case basis. If you do look at that whole thing and you come to that conclusion for a business reason, not a discriminatory reason, not a sort of a generic reason based on bias. So sex offender might be a better example. A lot of folks are reticent to rent to sex offenders, not because they think this person will be a problem in their property, but because they think it'll be harder to rent out their other units in the property if applicants find out that there's a sex offender living in the building. That would not be a proper basis to deny someone, because your reasoning there is, well, other people are prejudiced towards sex offenders, so I don't want to rent to this sex offender because of other people's prejudice. That's basing a decision on that discriminatory reasoning, not on a business or economic reason. So that is a great example of an improper reason to deny. If we take the arsonist as another example, if this person's conviction is relatively recent and they just haven't had the opportunity to show that they've put this bad behavior behind them, that it's not going to repeat. Arson, especially if it was, say, of a residence, that's pretty specific risk to both your business, not being able to rent a property that's got significant fire damage, and the safety of your other residents. So that would be a pretty good reason to deny someone tenancy. If it's been 6 years and they have a clean record since then, if they can show, they've taken some efforts at putting this issue behind them, at improving their relationships with other folks, not causing these kind of dangers going forward, then that's a good reason to rent to that person. The likelihood of reoffending at that point gets to be pretty low. When looking at financial responsibility, there's really two things that we're trying to measure. And this is a lot of the time why you look at amount of income, credit history, sources of income, to the extent that you're lawfully allowed to do that. And you're really trying to figure out two things. You're trying to determine, will this person be able to afford the rent? And if things go poorly, if there's damage, et cetera, will they be able to cover those costs as well? So that's where we come up with like the 2.5 and the 3-to-1 income to rent requirements. That's why we're looking at sort of what sort of debts do you have? Medical debt, usually you treat differently, generally speaking, than household debt on like a car loan or debts to a prior housing provider. So sort of why was that, and how can you look at this person and determine, will they be able to meet those two expectations that I've got, covering their share of the rent, covering any damage that might occur at the property. Tacoma specifically caps how high your income to rent ratio can be based on the affordability rating for the property. And they have, up on our slide here, we've got a link to determine, are you above or are you below the HUD fair market rent rate? And that sets the maximum income to rent ratio that you can require. A few specifics for the rental agreement itself that are addressed in Tacoma. We've got some sort of prohibited and mandatory to include protections about household members, about notice that the amount of time the resident is required to give for vacating, how pets are handled, and happy to at the end cover specific questions about each of these, but I will let folks read the slide to get that information overall. Setting occupancy limits, and this can be a touchy one for a lot of folks. Tacoma's got some real specific requirements. The fair housing sort of starting place, something called the Keating Memo, which came out of HUD back quite a while ago. I think it was in the 80s, and is still considered to be a good guiding principle now. Provides that you start with 2 people per bedroom in the rental, and then add 1 extra person who could be sleeping on a couch in the living room, for example. And that is sort of your starting place for an appropriate number of people to reside in a property. That then varies upward. If you've got a property that physically it can easily accommodate more individuals, and it tends to vary downward if the physical nature of the property can't accommodate even that many individuals. So if you've got a real limited septic system, for example, a lot of the time septic is rated based on how many people could live in a property, how much waste can it handle. Compare that, on the other hand, with a brand new building connected to sewer that has real great triple pane windows, real big windows, new fans, and great ventilation and air circulation throughout the unit. That one's going to be able to hold probably more people than that sort of default starting place. And then another one where I'm not going to read the slides, but city law has some specific size requirements as well. Washington law has been moving pretty aggressively against caps, statutory caps, on the number of individuals that can reside at a property. So these are a bit of an outlier in the general trend across the state because of those federal guidelines. It's commonly viewed by the federal government as discriminatory, disproportionately impacting families to have these kinds of limits. So they are getting less common, and we've seen a lot of them repealed in the last few years. So that could very well occur here as well. But this is a long-standing requirement from Tacoma that remains in place. Deposits and installments. We talked a little bit already about residents' right to request a payment plan. And our slide here is going to cover the specifics on timing for that based on the length of the lease, how many installments the resident can request. These payments are made with the monthly rent, starting with that first payment. So if you were to move in today, October 24th, and then you're only paying the 7 months of rent due between today and the end of the month, and then you make another payment in November, that resident's going to be required to make 2 payments in the next 8 days. They're going to pay installment number 1 of, let's say, 6 today at move-in with their October prorated rent payment, and then they're going to make payment number 2 on November 1st, and then December, January, February, March, in my example of a 6-month or longer lease for those installments that are paid. Each one is equal. You know, you're going to have to round to a penny here and there. And there are also some specifics on the nature of what can be charged and the sum of all those payments as well. Another one that you don't need to hear me read it off the slide. For rent increases, we have a minimum 120 days advance notice. That effective date for the increase, if you're month to month, corresponds with a rental period. So remember, 120 days is the minimum, not the maximum. You don't have to give exactly 120 days. Always better as much as you can to give more notice. You have to specifically identify the percentage amount that the rent is increasing in your notice. So at RHA, our RHA form, for example, we've got a spot for you to fill that information out. And then in Tacoma, you want to provide, again, the resource information, which you can do electronically. So like a link on the forms works as well, to housing resources for residents so they can investigate, you know, the nature of the property and get a review of their landlord-tenant rights as well anytime that you increase rent. Washington also adopted a law a couple of years ago, but it's been phasing in, requiring every city in the state to have a business license requirement for residential housing providers. So in the city of Tacoma, they prohibit you from issuing a rent increase until you have that business license in place. Late fees are capped at 1.5% of the rent each month, up to a maximum of $75 a month. That's going to potentially incur that 1.5% every month if the resident falls behind by multiple months until they do get caught up. They get a minimum 5-day grace period under state law to make that payment. So classically, rent is due on the 1st, which means it's going to be late on the 2nd, but no late fee accrues yet. They get all of the 2nd, all of the 3rd, all of the 4th, all of the 5th, and then day number 5, all day on the 6th to make the payment. Set on the morning of the 7th, when you check to see if the rent has come in, if it's still unpaid at that time, that's the earliest that you can assess that 1.5% late fee. If rent's due a later day of the month, you just push that whole period, that whole calculation back to that later date. Residents statewide have the ability to request that payment date be moved if they're dependent on a fixed source of income that's paid at a later time in the month. They can request that date be moved under state law up to a maximum of 5 additional days so that they can get the income in, you know, get it in the bank account, get that payment cleared, and then make the rent payment to you as the housing provider. There are a couple extra disclosure and notice details that go into that form, which we've got covered on the slides. Tacoma has a local equivalent to the state for cause termination requirement. What this means is that to end a month-to-month tenancy, you have to have both a city cause for termination or non-renewal and a local city of Tacoma cause. And you want to identify both of those in any notice that you give to terminate the tenancy. You want to make sure to comply with the minimum time periods required. And you want to provide any factual details that underlie the reason for the termination. So something like terminating the, I'm selling the property, give a little bit of explanation about that. If it is some sort of misbehavior issue with the resident, like repeated lease violations, you want to outline each individual lease violation and probably provide copies of whatever notices they got of that. Same thing for criminal activity. If you've got a family member moving into the property, a good idea to identify who that's going to be. If you choose to use both state and city allow this 120-day notice to terminate or not renew a tenancy for substantial rehabilitation, renovation, demolition, or change of use. The resident gets that's the longest period under state law, 120-day advance notice. And the housing provider provides, in addition to the termination notice, a relocation packet that alerts the resident that if they meet certain income requirements, they're eligible for a relocation payment. Mechanically, how that works is the half of that payment is paid by the city, and half of it's covered by the housing provider. So you give an initial an information packet to the resident, and they have the opportunity to apply through the city online. And then the city keeps everybody updated as to does that resident qualify, and if they do, instructions on making the payment. We talked a little bit earlier about shared housing and master lease requirements. These get into some real specifics about what space you can rent out, who has which obligations as compared against the sort of master lessor and the property owner. If you do operate that kind of property, you want to familiarize yourself with those specifics. There's a lot of kind of real detailed things. It's pretty intuitive, and if you are a thoughtful, responsible owner operator, you're probably going to align with a lot of those. But something you do want to familiarize yourself with, as it is, while it's pretty intuitive, it is different from how we operate and what we see the legal requirements are elsewhere in the States. It's a good thing to educate yourself about if you're in that area of industry. A couple of resources here on folks you can reach out to and places to get more information and resources through RHA. And we're going to pause here for a few minutes and take a few questions that I didn't cover through the materials.
I'm going to pause the recording as well.
Second unit, in my second unit, we're going to drift north and talk about local ordinances throughout King County, and do a little bit of kind of historic view as well as how some of these things have changed over time. As we did with Tacoma, we're going to hopefully touch on just that sort of joint state and city and give you that real that perspective, that direction on where do I need to be aware of and be watching out for specifics for my particular community. A large portion of housing regulation is all in one place, which is the Residential Landlord-Tenant Act. Residential Landlord-Tenant Act in Washington was passed in 1973. It was about a 3-year, 2.5-3-year process that the state legislature went through with a wide variety of different stakeholder groups to develop this. And it was originally based on the model, the federal level model Landlord and Tenant Act, and then has been revised and updated over time to try to account for the specific issues that come up both for housing providers and for residents in Washington. At the state level, the main method of enforcement is individual lawsuits between a housing provider and a resident. The Attorney General's office will very occasionally bring investigations and enforcement actions, but those usually relate to fair housing types of issues rather than Landlord and Tenant Act violations specifically. Overwhelmingly, it is a housing provider who believes the residents violated something, bringing usually an eviction action, but other types of lawsuits as well, or a resident, oftentimes with the help of pro bono and nonprofit groups, bringing enforcement actions against tenants, against the housing providers for their own violations, or asserting that, you know, I really should not get evicted in this lawsuit, say, because the whole reason this problem exists is you, housing provider, haven't been doing what you're supposed to. City and county laws tend to be enforced more frequently by local code compliance. And they have, depending on the issue and the jurisdiction, a wide range of different fines that potentially get issued. City of Seattle, where I do a lot of work, they're real proud that they've gone close to 2 years without having to issue a fine to a housing provider in Seattle city limits because they're able to use kind of education and the threat of fines to get voluntary compliance. So getting notified by a local code enforcement agency that you're in violation doesn't necessarily mean it's the end of the world for you, but treat it as an educational opportunity. You know, here's something I might have been doing wrong, and you know, how can I do better, be compliant, provide, you know, affordable, high quality housing. What's my opportunity to sort of learn from this? And a lot of the time, by approaching it that way, you can avoid any monetary penalties. Local regulation really got kicked off in the city of Seattle in 1981. Seattle wanted to adopt rent control, and state law prohibits imposition of rent control in Washington as a state level policy. So Seattle, beginning with its just cause eviction ordinance, has in the, what's that going to be, 44 years since then, built out a pretty robust local housing code reflective of, in a lot of ways, of that frustration. Just cause laws were originally developed in the United States as a way to protect from abusing rent control. So Seattle kind of did that in a little bit of a backwards way, but in a lot of ways it can be used for parties' mutual benefit as well. We've then begun to see, beginning in 2019, a lot of other jurisdictions, overwhelmingly but not exclusively in King County, adopting their own local housing codes, beginning with Federal Way and Burien, and then SeaTac most recently, Tacoma. Not on this slide, but Tacoma first adopted a local code in 2019 as well. Another area that we see these requirements is notices for if you're going to sell a property that's affordable to, that the rent is affordable to low income individuals. So that's usually defined as someone making 80% or less of area median income, wherever the particular property is located. And it is not a reason to terminate a tenancy, but rather it acts as an additional notification requirement. So particularly if you have a multifamily property, and these requirements exclusively apply to multifamily properties. In Seattle, though, in 2019, they changed their definition of multifamily property to mean 2 or more units. So even a duplex would be covered, even though that's considered single family under federal law. You can't terminate a tenant of a multifamily property for purposes of sale. What you're doing instead is notifying them of the upcoming sale to give them an advanced opportunity to find new housing, because when these properties are sold, a lot of the time the new owner needs to increase the rents to cover their increased, they got a bigger mortgage, they have higher operating costs. It also gives nonprofit and public housing groups an opportunity to assess, do we want to maybe be one of the potential buyers of this property so that we can keep those rents affordable. These notification ideas, Seattle adopted in 1982. It was modeled after a law in Washington, D.C., and there are a handful of jurisdictions outside of Washington that have them as well. There have only been in the entire country 5 properties that have ever been purchased by a public housing group or a nonprofit as a result of these notifications. So actually buying them are not what we see so much, but rather giving the residents who, right, statistically, and by how it operates, they have less means to quickly move if they have to give them a little bit more of a head start on knowing, what may be coming after the property is sold. Rental registration and inspection ordinances are another one that started in Seattle, and a number of other jurisdictions have adopted them. How they're implemented, jurisdiction to jurisdiction, varies really, really widely. So what you want to kind of look at is, are my rental properties in a jurisdiction that has one of these types of requirements? And if it is, go and look at how does it operate in my particular jurisdiction. The variety of different schemes is so great that we could spend this whole day today really talking about them. Seattle has a real comprehensive one that requires you to pay a registration fee every other year, and your property gets inspected at random intervals, but at least once every 5 years. On the other hand, Aberdeen and Lakewood, inspections are only ever come up if they are requested by somebody. They don't affirmatively go out and inspect properties. So sort of the range of how these things operates is pretty vast. The real really the only thing that's uniform about any of them is that you do have to register your property, certify either that you've had it inspected or that you've inspected it yourself and have determined that it meets all the code requirements for that jurisdiction. 3 cities have, well, 2 cities, but one of them has 2 different ones, have tenant relocation ordinances. Seattle and Tacoma each have one that triggers if you are demolishing, changing use, or significantly remodeling a residential rental property. They have notification requirements, and then for eligible low-income residents can get a payment prior to vacating the property. Seattle then has a second program as well, which is the economic displacement program, which provides that if you increase the rent 10% or more over the lowest rent in the 12 months prior to the increase, the resident who meets the income requirement can receive 3 months of rent at the older number in relocation assistance paid by the housing provider to the resident. Seattle's been having a lot of trouble with the managing and operating their economic displacement program, so it surprised me a bit if other cities want to adopt that because Seattle's had so much trouble administering their program in the it went into effective July of last year. So in the what does that make? 17 months that it's been in effect. These are really expensive programs to run. State law requires a city contribution to the relocation payment. So only really big cities, right, Seattle and Tacoma, are the ones that tend to have the budgets to be able to operate those programs. Another frequent increase policy that's been picked up, again, mostly but not exclusively in King County, is developing information packets and providing them to a resident. There are a lot of different times that these packets potentially get provided. We saw in Tacoma in the earlier unit that Tacoma requires it to be provided before collecting any information from a potential applicant. Then they have another packet that's included with the offer of a rental agreement itself. Seattle operates in a pretty similar way. We also see packets that come with notices that can potentially lead to eviction. So a real common one, for example, is if you're giving a notice to pay rent or vacate. In several jurisdictions, you're going to include a packet with that. They're usually just 1 or 2 pages, but it has a list of different resources that the resident can access to get help with low-income assistance or with emergency rent assistance or different types of things they can get. City of SeaTac has one that they provide that has, if you get a termination notice, if you don't have the option to stay, owners selling a single-family home, for example, or a family member's moving into a rental property, resident's going to have to move no matter what, right? So that packet focuses on assistance with finding new housing, with getting moving assistance, you know, if you need that. So different kind of information in the different sorts of packets, depending on the particular jurisdiction that's developing it, and you know, what are they using this packet to try to do. Tacoma was really a leader in that type of notice specific packet development. A lot of cities increase the minimum amount of time that is required. State law requires a minimum of 60 days advance notice before increasing rent. Prior to 2019, that only applied to month-to-month tenancies. If you were offering someone a new, not 2019, excuse me, prior to 2020, if you are offering somebody a new rental agreement, they had a fixed term contract. You didn't have to tell them in advance what the rent was going to be on the new contract, unless they were in like the HCV, the Section 8 program, for example. There's some notification requirements around that one. That changed statewide in 2020 to require a minimum of 60 days, regardless of the nature of your tenancy. So both for month-to-month tenants and for offering a new rental agreement. You had to at least let the resident know what the rent was going to be on that new agreement at least 60 days before it would go into effect. Other jurisdictions quickly adopted that policy, and a lot of them added extended notice periods beyond the 60-day state minimum as well. It's worth, and then we've got them all set out on the slide, what all the different jurisdictions are and what their requirements are. There are kind of 2 main ways that this is done. One is the city of Seattle, for example. They have a single notice period required no matter what. In Seattle, it's 180 days, whether you're increasing the rent 1 penny or whether you're doubling or tripling the rent. It's 180 days advance notice. Other jurisdictions will look at how much the increase is to decide how long the period of notice is. So just using the slide to look at, for example, if your rental property is in the city of Kirkland, if you're increasing the rent less than 3%, then you give the state required 60 days notice. If you're increasing it by 3%, by up to 3%. If you're increasing the rent by more than 3% in Kirkland, but less than 10%, you give 120 days notice. And if you're increasing the rent by more than 10% in the city of Kirkland, then you give 180 days notice. So we've got, kind of depending on how big the increase is, 3 different minimum notice periods. And that staggered length of time based on the length of the increase, or based on the amount of the increase, excuse me, is really the more common one that gets picked up. These are all city level requirements to go above the 60 days, with the exception of King County. There are a bunch of unincorporated parts of King County, and you follow their requirement there, even if the mailing address for the property has a city name on it. So there's, for example, south of Seattle city limits, there are a bunch of areas where your mailing address says Seattle on it, but you're not inside city limits. So you would follow King County's requirement, not city of Seattle. Meanwhile, if you are in, say, Bellevue, if you're in Bellevue city limits, they don't have any local requirements. So the unincorporated King County requirement would not apply there, even though Bellevue doesn't have specifics. The King County one is just for areas outside of any city's limits. 4 cities throughout the state require specific delivery mechanisms for your notice of rent increase. If you're not in one of these 4 cities, then you just have to give it in a way that is reasonably designed for the tenant to actually get that notice requirement. So there's no specific delivery. What we usually recommend outside of these 4 cities is giving them at least 1 paper copy and then 1 electronic version if you have the ability to do that as well. So a couple of examples on that could be if you have a rental portal, sending notice to the resident through the portal and also mailing one to them. Or if you've got a single family property with an on-site manager, you might want to go and post one on the door of the property, as well as send an email, for example. But the state requirement doesn't have any specifics. It just has to be in a way that is likely to give the resident actual notice. If you're in Auburn, Burien, Olympia, or Seattle, they have specific delivery requirements, which we see on the slide for each of those. By and large, it's going to be the same way you would give an eviction notice, so that conspicuously posted on the door and mailed to the resident. City of Seattle has a bunch of additional real jurisdiction-specific requirements depending on the percentage of the increase. And those delivery requirements for Seattle arise out of their EDRA program, primarily the economic displacement rent program. So most of them apply to 10% or more increases. Everywhere in the state, residents have the right to request a move-in fee payment plan. A few different jurisdictions, again, all showing up on the slide, extend the amount of time above and beyond what state law provides for. So state law provides that the resident must affirmatively request the installment payment plan, but if they request it, the housing provider has to give it to them. A few cities, Tacoma, for example, say that the housing provider has to go out and affirmatively offer that to the resident, but that's definitely a minority. Throughout most of the state, the resident has to know about this requirement and go out and actually ask for it. The minimum payment schedule is for a tenancy of 3 months or more, 3 installments. So in my lease that starts today, 12-month lease that starts today example, today's October 24th. So you'd make installment payment number 1 today at move-in. Installment payment number 2 would be due November 1st, and then payment number 3 due December 1st. If you have a tenancy of less than 3 months, so that could be 2 months and 29 days. It could be month to month. It's 2 installments. So in my, say I get a month-to-month lease, prorated rent for October due today, and then November rent due November 1st. I'm going to make 2 installments, 1 today and 1 on November 1st. A bunch of jurisdictions extend this. They create, a lot of the time, they create a 6-month cutoff. So you get a slightly longer than that state 3 installments if you got a 6-month or longer lease. Overwhelmingly, markets throughout Washington are that your initial lease is going to be either 6 or 12 months. So that one comes into play pretty darn frequently. They also, local laws may not apply if you have a really low total for move-in fees. So if you don't pay a last month's rent at all, and if the total of all your move-in fees, so any sort of non-refundable like a cleaning or an admin fee, as well as any refundable security deposit, if the total of that is less than a quarter of a month's rent, then these installment payment requirements, generally speaking, don't apply. But you'll want to look at your city specific if you're in one of the cities listed here on the slide for how it works in your particular jurisdiction. There are also a number of cities, and it's almost the same list here, which cap what you can charge at move-in and the total amount that you can charge. So we see prohibitions on pet fees, for example, or on maximum sum of all your both refundable and non-refundable amounts are, the pretty frequent requirement is that they can't exceed 1 month's rent. Several jurisdictions allow you to go over that if you have a refundable pet deposit, but they don't allow that for a non-refundable pet fee. Some of them will prohibit what you can charge, especially in the non-refundable range as well. City of Seattle, again, the easy example, because they've got the most of these things, and theirs are the most specific. The only non-refundable charge you can have in the City of Seattle is a cleaning fee and a screening fee. The screening fee counts towards your cap in Seattle if it's paid directly to the housing provider. If it's paid to the screening company rather than the provider, it doesn't count towards that cap. And then you add up, if you're in Seattle, a cleaning fee if you charge one, plus any security deposit, and the sum of those two things can't exceed 1 full month's rent. Each jurisdiction does it a little bit differently, but that general sort of calculation is how they all operate, with local variations jurisdiction to jurisdiction. Seattle also caps that cleaning fee at 10% of 1 month's rent. Cities with a local equivalent of for-cause termination that supplement the state requirement tend to, it's not quite universal, but they tend to also prohibit housing providers from using the exemption. At state law, there's 2 ways that you can be exempt from the state for-cause termination requirement for fixed term tenancies. One is if the initial term is at least 6 months and all subsequent terms are at least 6 months. Residents never been month to month, then you are exempt from state for-cause termination requirements, and you can just give a 60-day no-cause non-renewal. The other route at state law is if you have an initial term of 12 months or more, so not 11 months and 29 days, but a full 12 months. So if we had a lease starting today, October 24th, it would have to go until at least October 23rd, 2024. That's a full 12 months. And all renewals, there's always a fixed term renewal as well. So never the option to go month to month, resident never in fact goes month to month. But then there's no minimum time period for renewals when you've got that 12-month or longer, and you would be exempt from the state for cause termination requirement, and you can just give a minimum 60-day no cause termination. That does not apply if you're in one of the jurisdictions up here on the screen that has a city rule that says you can't do that, that you have to have one of the city causes for non-renewal. And it does not apply if you have a subsidized tenancy. The Housing Choice Voucher Program, Section 8, has a federal requirement that you only terminate the tenancy for cause. Section 8 voucher holder cannot receive one of these 60-day no cause terminations, even though state law might provide that they're exempt from the state for cause termination requirement. The amount of late fees are capped locally in a whole bunch of jurisdictions. This is another one that we see largely focused around the Seattle area, but not exclusively. And the are all, I think, yeah, all the caps that are in place as of right now, October 24th, are up here on the screen. They tend to be either $10 or 1.5% of a month's rent. CTAC went a little bit higher at 2%. Late fees were prohibited statewide as a result of the governor's declaration of emergency for the COVID-19 pandemic from effectively from March rent of 2020 through the end of the governor's eviction restrictions, which I'm getting rusty on when that happened now. I want to say it was October 31st, 2022. The city of Seattle extended that for 1 more year through October 31st, 2023. And then there's a bit of a variation locally. We talked about in the earlier slide, but it's worth emphasizing again. State law requires a 5-day minimum grace period for any late fee that you're going to impose, but state law doesn't cap how much that late fee can be. So you have to give at least 5 days after the rent due date before you can impose a late fee. If we looked at October, most leases require that rent be due on the 1st. So if that's the case, the resident cannot be imposed a late fee if they pay on the 1st, of course, because it's on time. But also while the rent is late, they can't get a late fee on October 2nd. 3rd, 4th, 5th, or October 6th, because that's still in that mandatory 5-day grace period. You get up on the morning of the 7th and you check to see if you've received the rent. And if it still isn't paid, that's when the earliest date that that fee could possibly be put in place. A few additional rules around who can live in a property. In the city of Seattle, they have something that it doesn't have, this law doesn't have an official title in Seattle, but we tend to call it the roommate ordinance. Seattle's roommate ordinance is very, very complicated, and I'll be happy to address any questions that folks have on this one to get into specifics, but the general overview is that every resident or every household in Seattle can add one extra person to live at the property as long as they're not violating any maximum occupancy requirement. And that is concerning the relationship between the housing provider and the resident. If you have a subsidy, like a Section 8 voucher, for example, there's a separate requirement between the resident and the housing authority for how that operates and what they can do there. The housing provider is not involved in that. That's between the authority who issued the voucher and the household. This is about, and this city requirement, and we'll get to the state one as well in just a moment. The city requirement is about the relationship between the housing provider and the resident. So that says that the resident can add in Seattle one additional person to the household. They're required to tell the provider within 30 days of when that person moves in that they're living there. And the housing provider then has the right to ask that they be screened, and based on the results of the screening to decide whether they want to just make them an authorized occupant or whether they want to make them financially responsible by adding them as a tenant on the lease. If they do add them as a tenant, that one extra person that the household can add then hasn't been used up. So the household could then add yet one more person. It's important that you, however you choose to enforce this, it's important that you do it in a uniform manner, else you may be violating state or federal laws around household composition and families with children status, for example, a protected class at the federal level, or size of household and household composition, which is protected class at the state level. If the individual in addition to that one extra person in Seattle, a household can add an unlimited number of immediate family members. And for this specific law, Seattle has a unique definition of immediate family. It's different and it's more inclusive than any of the definitions they have of immediate family for any other purpose. If the person that is joining the household is an immediate family member, the housing provider can screen them, but they have to make a decision on, am I going to add you to the lease as a financially responsible party, or am I just going to make you an authorized occupant? They have to make that decision before running the screening. The screening is just sort of for informational purposes. The housing provider can't make any decisions based on the information in the screening. And important to note that other than the requirement that the household disclose to the housing provider within 30 days of someone moving in who's living there, they have that absolute right to have that one additional person, as well as an unlimited number of additional family members subject to any occupancy maximum. So your screening is about, how am I tracking this person? Am I making them an authorized occupant, or am I making them a tenant? And then, for sort of security purposes, knowing who lives in the property. It's not controlling whether I can let them live there or not. The only reason you would potentially in Seattle terminate someone is refusal to disclose who's living there. Those are very complicated cases, so I really encourage people to get individual advice from an attorney if you're in Seattle and you're confronting that problem. At state law doesn't speak to household composition during a tenancy. That's between the landlord and the tenant to decide what rules do they want to agree to and what do they want to put in place in the lease. State law speaks to if all of the leaseholders, everybody who's named on the lease, if they permanently vacate the property, under state law, anyone who's been living at the property for at least 6 months has the right to take over the tenancy. To be allowed to take over the tenancy, they have to have been living there for at least 6 months before the last named tenant on the lease vacates, and they must submit to screening. The housing provider runs the same screening process that they would do if they were advertising the unit vacant. And if the remaining folks who are living there but weren't one of the original leaseholders, if they meet that screening requirement, then they have to be offered the opportunity to take over that lease. So it's not a new lease, they're just taking it over. So if they were already month to month, housing provider can say you're going to stay month to month. If we're partway through a fixed term lease, the housing provider says, all right, you can finish out that term. And then they function as the resident from that going forward. So that applies everywhere. That's state law. Then finally, for shared housing in the city of Tacoma, we have those extra requirements that we highlighted in the earlier unit. So that's my overview on household composition. Happy to cover in our Q&A time that we're going to have in about 10 minutes. Any extra specific questions to the extent on that time allows. City of Seattle prohibits physical lockouts during the winter for specific covered households, and that's usually income-based. And there's a few exceptions to that for certain emergency needs or uses. And then they prohibit physical lockouts for children, so that's anyone under 18, for anyone enrolled in school, primary education, so 1st to 12th grades, for educators, anyone who works at or for a school is considered to be an educator in the city of Seattle, and for parents and guardians of minors who have custody. So it doesn't matter if the child only stays in the rental unit 3 days a week. If they stay there, any amount of time, then that parent or guardian has at least partial custody, and they cannot be locked out during. So those 3 categories: minors, educators, and parents or guardians of minors who have custody during the school year, and that's defined as from the first day of school for Seattle Public School District through the last day of the school year. That tends to run from very late August or about September 1st through sort of mid to late June each year. You can still issue notices as a housing provider during that period. You can still issue termination notices. You can still bring unlawful detainer actions. The only thing that's prohibited is the sheriff's office can't do the physical lockout if one of those 2 winter or school year eviction restrictions applies. A few different jurisdictions have added, and we've got what they each are on the slide, a requirement prohibiting a housing provider from increasing the rent if the property has physical defects that mean it's not up to code. For the most part, so in Seattle, in King County, and in SeaTac specifically, the way that this works is if a resident gets a notice of a rent increase and they believe the unit doesn't meet code, they should immediately notify the housing provider of the repair needs, right? Same way you would always do that. You make a written request for repairs. If the housing provider doesn't respond and address those issues, the resident can then complain to the local code enforcement office for whatever city they're in, and the city will come out and inspect the property. State law requires that the city come out and inspect within 3 days. Cities are usually pretty good about doing that. But if you're a resident and you're having this kind of issue, important, it might help reminding the city, hey, by state law, you got to do this within 3 days. So, let's get going here if they can't come out quickly. The city will then notify the property owner of any code violations, and the rent increase cannot go into effect until the city confirms that all those code violations have been remedied. So if let's say a rent increase was scheduled to go into effect on November 1st, and the unit fails inspection today, October 24th, and then ultimately housing provider gets the repairs remedied, and the city does a follow-up inspection and confirms that the unit is now up to code on November 15th, let's say. The rent increase for November is going to go into effect on a prorated basis the next day, November 16th. So the resident will pay on the 1st, they'll pay their pre-increase rent for November. And then on November 16th, when the resident and the provider are notified the increase is now, that the defect has been repaired, so the increase can now go into effect. They will prorate then that increase for the 16th through the end of the month. So in that's an easy example, it's going to be half for that month, and then the full increase would take effect with payment of December rent as well. Tacoma does it a little bit differently. City of Tacoma just requires that the provider have a current business license that identifies that this property is covered by that business license in effect before issuing the increase. If you somehow missed this business license requirement and you issue an increase, and then you learn about it, you have to issue a new rental increase because you have to have that license before an increase can be considered to be valid and enforceable. There's also a coalition and this one's all the member cities of this coalition are in the city in King County, but some of the jurisdictions that have adopted the package of housing regulations that they're advocating for, some jurisdictions outside King County have adopted those. Tumwater and Port Orchard, for example, have both adopted part of this. But Arch, this what is it? It's an inter-government organization, so it's funded by multiple different city governments. Developed a recommended package of local housing requirements, and then they pitched those to a bunch of cities, and a number of different cities adopted all or part of them. The reason it tends to be kind of burdensome on housing providers is that every city tweaks that package a little bit. They adopt only part of it, or they change some of the requirements, and that can be pretty difficult if you operate in more than one city, keeping track of city by city differences. It also robs housing providers in those cities of a lot of state level benefits. The Washington Attorney General's office, for example, provides a lot of guidance materials to housing providers free of charge. If you're in a city that has adopted some or all of these ARCH requirements, then some or all of that free statewide material doesn't work for you, because you've got these conflicting or different local requirements. So you have to go out and pay somebody, an attorney like me, or a bit more accessible way, join a group like RHA to get access to these. So as an organization, RHA tends to oppose these kind of things, prefers state level uniform regulation, because that lets people in those jurisdictions get access to a lot more low cost or free resources to maintain compliant housing. The things they've been focusing on lately, so these are if you're not in a jurisdiction where you already have these kind of requirements and you might expect them to be coming, these are the kind of things you might expect to see your city council or county council talk about. Rent increase caps based on the amount of increase, looking at the sort of staggered amounts, the greater that you increase rent, and such. And I'm not going to kind of read through that. You can kind of read through those yourself to the extent that you're interested in. And then, again, as we talked about with Tacoma, really sort of educate yourself and come into a class like this today. It is a great way to do that about what's going on with different types of initiatives and share your perspective and your opinion, whether you're pro or con, with your legislators. You know, take advantage. You have a lot of information that policymakers don't have because you're in this industry. So share your experiences and your perspective, both in favor and against.